Americans for Prosperity North Dakota proudly supported important policy improvements that broke barriers for all North Dakotans this legislative session. From tackling unnecessary and burdensome occupational licensing standards to fighting for tax relief, AFP is proud to have played a part in improving the lives of North Dakotans this year. Join AFP today by visiting www.afpnd.org. This advertisement was paid for by Americans for Prosperity. Welcome to the Plain Talk Podcast. I'm your host, Rob Port. Later in the show, Fargo defense attorney Mark Friese, who is a frequent contributor to SayAnythingBlog.com and a regular guest here on the podcast, he comes on to talk about a problem that we're having in North Dakota's criminal courts. Essentially, it has to do with drug testing. Now, North Dakota has a law which essentially says that people who are charged with a drug-related felony have to, if they're going to get out on bail, have to undergo drug testing while they're out on bail. It's not unlike the 24/7 sobriety program that you've heard of with regard to people who have multiple DUIs or have particularly egregious DUI charges against them. They have to show up on a regular basis and have their sobriety tested by like law enforcement or something like that. So essentially, this is the same for people charged with drug crimes, and it doesn't matter whether or not they've actually been using drugs or not, the status of whether they're addicted or not addicted or even using drugs. I mean, maybe there was somebody who was just possessing drugs, or maybe they were a dealer or something like that. If their crime is related to drugs, they have to undergo this testing. But the thing is a lot of these people can't necessarily afford the testing. Now, the genesis of our conversation was a article that I read in the Minot Daily News regarding a criminal case where the person was saying that they can't afford the drug testing. It's twice a week. It's $35 a test. So you're talking in the neighborhood of around $300 a month. And this is a person who, obviously they're in the middle of a criminal case. They're facing possible jail time. And, the prosecutor in that case is basically saying, well, if he can't afford the drug testing, I guess he should get a better job, which, gosh, is really obtuse, because how do you go about getting a job when you're in the middle of, or getting a better job even when you're in the middle of a case where criminal charges against you? Now, remember, this is pre-conviction. This is before the person has been adjudicated guilty of the crime. This is just about them getting out on bail. So, I think there's some interesting questions to ask about whether or not that's even constitutional to require this. Anyway, it's an interesting discussion that's coming up a little bit later in the show. But before we get there, it seems likely that we're going to have another debate about legalizing marijuana in North Dakota. And in fact, we've already legalized medicinal marijuana. So this is pertinent. One of the, if we remember from the last legislative cycle, the 2018 election cycle, a lot of the people who were advocating, and even going back to the 2016 cycle, a lot of the people, when we were debating medicinal marijuana, a lot of the people who were advocating for legal marijuana argue that we should legalize marijuana because it helps reduce opioid overdoses. Now, the theory behind this, and it was backed up by a 2014 study, but the theory behind it was essentially that marijuana is something that can be used to treat pain and chronic pain. And so the idea is that if you can, instead of using like an opioid drug, like a fentanyl or something like that, and instead of using those sorts of drugs, if you can use marijuana to treat your pain, then you're less likely to get addicted to opioids, because obviously marijuana, in terms of addiction is a much different animal than opioids. It's just far less addictive. And I think most reasonable people can agree, if you could treat pain with marijuana instead of opioids, well, that's probably a win. Now, like I said, there was a 2014 study which seemed to indicate that states which were legalizing marijuana to one degree or another were seeing a lower rate of opioid overdoses. In fact, from 1999 to 2010, that's when this was a 2014 study, but those are the years for which they collected data and analyzed data, 1999 to 2010, they found that states that had ended marijuana prohibition to one degree or another had an average of 25% lower rates of opioid overdoses. And what's more is during that timeline, as you went along from 1999 to 2010, that gap got larger. seemed like compelling data, right? If you looked at the information, essentially, it sure seemed like legalizing medicinal marijuana was helping people avoid becoming addicted to opioids. Now, here's the problem, though. There's a new study out. It was conducted by researchers based mostly at Standard, and it essentially continued the same study, right? Same methodology and everything, except they went from 2010 and they continued on through 2017. So now you're looking at data from about 1999 to about 2017. And what they found is that starting in 2012, the trend started to reverse. States with liberalized marijuana policies began to see higher rates of opioid overdoses, to the point where those states had a rate of overdoses 23% higher than the other states. Now, it's obviously a problem. If pro-marijuana activists could use the earlier study as an argument for legalization, I suppose their opponents can now cite this study as a rebuttal. Now, the researchers themselves are cautioning against drawing conclusions, right? Because there's a lot of people who are going to say, well, see, look at what marijuana does. It didn't draw people away from opioids. It increased opioid abuse. But it seems actually that the more likely what's going on here is a correlation, not causation phenomena, right? I'm sure you've probably heard of that, where if you have a trend and two things are true, the one thing being true does not necessarily cause the other thing being true, right? Sometimes two things can just be correlated, but not with one causing the other, right? Like if you wear pants and then it rains outside, it didn't rain because you wore pants. Those are just two things that are correlated. One did not necessarily cause the other. And so what the researchers themselves are saying is, I quote, medical cannabis users are about 2.5% of the population, making it unlikely that they can significantly alter overdose rates. So what the researchers are saying is it was unlikely that marijuana was the reason why overdose rates were lower before, and it's unlikely that marijuana use is the reason why opioid overdose rates are now higher. So I don't think we can claim any longer that marijuana will reduce opioid-related problems, but marijuana opponents can't exactly claim they'll make them worse either. The study's authors do note, though, that even despite this new information, marijuana can be good for society, just maybe not the cure for the opioid epidemic. Again, I quote from the study, cannabinoids have demonstrated therapeutic benefits, but reducing population-level opioid overdose mortality does not appear to be among them. Now, this is important information because, once again, North Dakota is going to be debating marijuana this coming election cycle. At least I assume so, as you probably know from previous posts on SayAnythingBlog.com and previous episodes of this podcast. There's been something of a fracturing in the marijuana legalization movement in North Dakota, and we'll see what comes of it. But I suspect that there's going to be a ballot measure on the ballot in 2020 that seeks to legalize marijuana in one way or another. And I suspect that a lot of the people pushing that ballot, you're probably going to hear the talking point that this will, help draw people away from opioid drugs and will help, lower, the problems, the societal issues we have with opioids. But as this data shows, that talking point probably isn't good, which is also a lesson for all of us, by the way, is you can't ever just look at one data point. You can't ever just look at one study and say that it's conclusive. Societal trends are complicated when you're talking about crime statistics, drug statistics, economic numbers, demographics, populations. There's so many variables. The reason why people do things are very, very complex, and rarely does one variable have, an enormous impact on another issue. It can happen. It just doesn't happen maybe as often as we would like to think. So just a little update for the coming marijuana debate, and even as we debate the implementation of medical marijuana in North Dakota now. That's it for the rant. My interview with attorney Mark Friese coming up next. This episode of the Plain Talk Podcast is brought to you by Energy of North Dakota. Oil and natural gas from North Dakota strengthens all of America. And through our abundance of talents, innovations, and technologies, energy responsibly produced here translates to worldwide economic stability. With producers and our communities working together, we're securing a sustainable future that generation after generation can build on. It's all happening right now with Energy of North Dakota. Learn more at energyofnorthdakota.com. In North Dakota, there's a state law, and my guest is going to talk more about what specifically the law is, but there's a state law that requires somebody who is out on bail, who gets bail, right? They've been accused of a crime. There is currently a criminal case proceeding against them, and they're out on bail. And one requirement of that bail in drug cases is that they get drug testing. But what happens if they can't afford the drug testing? Well, it's an interesting question. Fargo-based defense attorney Mark Friese is here to talk about it with me. Mark is he works for the Vogel Law Firm and handles criminal cases around the state. And Mark, what is the current law that I'm referring to? Can you give us some specifics about that?
Certainly, there is a statute that was passed in 2005 that requires in felony drug or drug paraphernalia cases that the judge, as a condition of pretrial release, has to order that the accused submit to random drug testing as a condition of their release. There are exceptions. The exceptions are limited, but cannot relate to methamphetamine cases. So methamphetamine cases, irrespective of whether the defendant's in treatment or in counseling or has demonstrated abstinence from the use of controlled substances, they're required to submit to random testing.
So essentially what this is, is it really random though? Because I'm reading a case out of Ward County here. It was reported on in the Minot Daily News. It was a gentleman, and he's facing criminal charges relating to methamphetamine possession or use, something along those lines. But he had this condition that we're talking about, and it wasn't random. I mean, the Minot Daily News says that his bond conditions require that he undergo twice weekly drug testing at a cost of $35 a whack. So we're talking about, $70 a month in a 4-week month. We're talking about $280 to probably over $300 a month, depending on how, I guess, the days fall. And I mean, that doesn't seem random at all to me.
Yeah. The term used in the statute is random, but the statute also says the court shall order the frequency of the random testing and the location at which the testing will occur. Yeah. So, and then in addition to that, the costs are borne by the person who's ordered to submit to the testing. It creates all sorts of complications when defendants are indigent, and it also hampers treatment. For example, if a defendant has enrolled into residential treatment and as part of their treatment protocols are going through testing with their treatment provider, they may still be ordered to submit to the testing that's ordered by the court.
No. The question here is what you just brought up is the indigent question, because, and again, out of this case described in the Minot Daily News, this gentleman went to court and said he couldn't afford it. It's $70 a week. This man is facing criminal charges. I can't imagine that your employment status, I would think, would be precarious at best if you're facing criminal charges in court to begin with. There's obviously he has a court-appointed attorney, but going to court is not a cheap proposition to begin with, and now he has to pay for this testing. He's saying he can't afford it, and the drug testing company that he's been ordered basically to report to and take these tests from, they're basically failing him because he's showing up and he's saying, listen, I can't pay. He's not taking the test. They're then reporting back to the court he's failing these drug tests. What do you do if you're an indigent defendant in those circumstances where you just don't have the money to pay?
More importantly, what happens to the person? They end up being put in jail at probably the cost of $70 to $100 a day at taxpayer expense, that we hold them in jail simply because they're not able to economically afford the testing. The defendants really, as you indicated, they have no choice at all. If they're not employable, or if they're working at minimum wage and they have a choice between being able to feed their family or having to do random drug testing, I would hope as a society we would want them to feed their family. But it happens, and it happens regularly. And our system is in many respects backwards, and this is one of the areas that we're backwards in.
Now, this is all we need to remember as we discuss this. This requirement is pre-conviction. So, all of our assumptions about innocence, although assumptions that we make imperfectly a lot of times in these criminal proceedings, all of our assumptions about innocence until proven guilty are in place. This person has been accused of a crime. They have not yet been convicted of a crime. And yet the state is requiring them to basically get these drug tests. Is that constitutional? Now, I know in the Minot Daily News article, one of the prosecutor, I believe, said that this has been, appealed to the state Supreme Court, and the state Supreme Court upheld it. You've actually reviewed that ruling, though. You said that's not actually the case. It was more like the Supreme Court dodged it. So tell me a little bit about the constitutionality of this.
Right. I agree with the prosecutor that the issue has been before the Supreme Court in North Dakota, but the Supreme Court in North Dakota did not address the merits of the constitutionality of the statute. There was a very well-reasoned district court decision that came out of Cass County in 2005, shortly after this statute was passed. The district court here in Cass County concluded, rightfully in my view, concluded that the legislature had exceeded its authority by directing courts in every drug case to impose this condition. Historically, the conditions of release have been established by judges. Judges are in the best position to determine what works best for each individual defendant. They have a list of factors that are established by rule. That rule is promulgated by the Supreme Court, and it's the province of the judiciary to determine the bail conditions. The district court judge here in Fargo concluded that the statute, which intruded upon that judicial determination, exceeded the scope of the legislative authority, that it was an improper determination by the legislature, and held that it was unconstitutional. The case was appealed to the North Dakota Supreme Court, but unfortunately, by the time the Supreme Court was able to hear the case on the merits, the individual defendant who was involved had pled guilty to the offense, was placed on probation, and was no longer subject to bail conditions. So the Supreme Court said the issue is moot. We no longer have to address it because the defendant is no longer subject to bail conditions. So it's an open question. They did not address the merits of the constitutionality, but I personally think that if they were forced to address the merits of the constitutionality, they would conclude that it is unconstitutional.
Well, how are we going to get it before? If that's the Supreme Court stance, is that it's if the criminal case is settled before it reaches them, that they are, it's a moot matter. That essentially puts defendants who might want to question the constitutionality of this, they're basically in a foot race with their proceeding in the district, right? They have to somehow try to get the Supreme Court to consider their case before the case is actually settled by the lower in the lower court, right? How does that on a timeline? How does that happen?
Yeah, or worse than that, we keep people on bail conditions rather than adjudicating their case because we have to get the issue squarely before the Supreme Court. I personally think that the best way to do it is to fix the statute. Go back to the legislature, modify the language of the statute so that the district court has and maintains discretion to make exceptions, add a preference that there be testing if it's possible. The suggestion that you raise in your blog post is to provide funding if there's a determination of indigency that an individual defendant cannot afford it. And look, Rob, this is a good idea in some instances. This drug testing is a safety net for people who are dealing with addictions to try to avoid it. So in the right case, under the right circumstances, and in conjunction with treatments and assessments, I think that this is a good thing. But the problem is when we use it and end up placing people in jail instead of in the community, that's where the problem arises because they simply can't afford it.
When we're saying that your opinion is that this statute is unconstitutional. Is it unconstitutional because it's the legislature usurping authority from the legislative branch? Is that what makes it unconstitutional?
Yeah, they're invading the province of the judiciary by imposing this condition. The judges, a pretrial, as you indicated, this is a presumptively innocent defendant under the Constitution, and they're subject to release conditions which are established by the court. By directing the district court in every case, under every circumstance, to impose this condition, they've invaded that province. It's a usurpation of the authority of the court. It's a separation of powers issue. I am
a rodeo clown blogger and not a learned legal scholar like yourself, but I worry about the position of essentially punishing people before they're convicted. I mean, to me, this looks, I mean, if we're saying, okay, everybody who's in these circumstances, has to undergo, has to pay this for this testing. I mean, to me, that almost rises to the level of you're being punished. I mean, this is a fine, and when it's happening before you're even convicted. Am I off the rails in thinking this?
To some extent, I concur with you. To some extent, I disagree with you. Recall, though, that once an individual is charged with a crime, they're brought before the court, and then the court has choice. The choice is keep the person in jail pending resolution of the criminal charge, or release them on conditions that will reasonably assure their future appearance in court and, to some extent, assure the safety of the community. This program, the drug testing program, the 24/7 sobriety program for people with repeat DUI cases, are instances where it seems to be a punishment, but it also appears to be a measure to make sure that the person is going to make it back to court and to make sure that the community is safe. So on balance, I think reasonable conditions are appropriate. It's an alternative to keeping the defendant in jail prior to trial, but there are options available beyond charging an indigent defendant $70 a week. There are patches, for example, that could be placed on the person and subjected to testing, which are much more affordable, much more cost effective, but not every community has that program, and not every community has the resources to do that. So on an individual community-wide basis, there are disparities that result. I think that the better process here is to develop a standardized program to provide financial assistance to the defendants who show the court that they're not able to pay for it, and to use this statute in conjunction with counseling or treatment to try to assist people as they go through the process.
I think also is just letting the judges decide. I think to me where it becomes where it sort of crosses that line from being a reasonable condition for release so that somebody awaiting trial doesn't necessarily have to sit in a jail cell. It's better. I think it's better for them. I think it's probably better for the taxpayers if we can let them out on some sort of conditions set by the judge who, like you say, is in the best. We could question the decisions made by any given judge, but in the aggregate, I think judges generally make the right decisions in these cases. To me, where it transcends and becomes a punishment is we're saying, no, this is what it has to be in every single case. To me, that's not a condition anymore. That's a punishment.
Yeah, and use your example to an extreme. Assume that I'm a drug dealer. I don't use drugs. I'm profiting by this epidemic of drugs, and I'm charged with possessing or distributing drugs. I have no history of using drugs. I'm simply a criminal who's engaged in the distribution of drugs. I go into court, and even though there's no nexus, there's no connection to my drug testing because I have no shown history of drug use, the judge is obligated to do it. I think a lot of people would say, well, if you're caught red-handed, you should be punished, and this is another measure of punishment. But that underscores the point that you raise, is that there has to be an individualized determination. I personally have had clients that enroll into residential treatment, and they end up with their bail subject to being revoked because they're in a residential treatment program and not able to go to the remote testing facility. So we got to go back to the court and ask for an exception in those cases. But I agree with you. The issue is one of an individualized determination and what is necessary to make sure that the defendant will appear in court and that the community safety is protected.
How much of this? I mean, how often does this happen? How often do we have in a given county or whatever? And obviously, that's going to vary from size to size. I mean, is this really common? I mean, is this at like every drug case, or is it just methamphetamine cases? When does this kick in?
It's every felony case involving drugs or drug paraphernalia. So it's very, very common.
Okay.
And one of the other pitfalls of this is sometimes it forces defendants to resolve their cases more quickly than they should. They don't have ample opportunity to review the state crime laboratory analysis or even to have the substances analyzed. They don't have the opportunity to explore defenses in order to get off of the bail condition and to be placed on probation. And if they're on probation, the Department of Corrections has resources available to assist with drug testing for defendants who are financially unable. But, Rob, I think that there are 2 points to make here. I indicated that our system is backwards. We historically have had to put people in prison or jail to get them counseling or treatment. There's a movement to away from that. And this statute didn't have the foresight to recognize that there are going to be people who can't afford the conditions. Secondly, there are statutes, and the legislature is recognizing some of this in their pilot projects to try to use pretrial services where the Department of Corrections or even jail staff are able to provide services, and they're funded through appropriations by the state so that individual defendants can be earmarked and they're able to do random testing or even treatment or counseling prior to their case being resolved. And I think that's where the fix really is on all of this, is to establish pretrial services, to identify needs and risks individually, and to place people into programming before the criminal case is resolved, rather than forcing people to plead guilty and forcing cases to be pushed through the system in order to have resources available for treatment.
Who conducts these tests? I mean, is it like a government entity? Is it a private entity? Who I mean, when the court says you got to get drug testing, who do they have to go to?
All of the above, and it depends county to county. Some counties have patch programs available. For example, in Cass County, our local jail, we have a coordinator from the sheriff's office who's able to do patches and install patches. In other communities, they don't have access to those programs. So the statute specifically says that the court shall identify the frequency and duration of the testing as well as the location where the testing occurs. So it varies from community to community.
So is it safe to say that there are private companies out there that are doing this testing and making, and I guess the reason is when I look at public policy too, when we create these mandates, a lot of times we're also creating a revenue flow for an interest that can lobby the legislature, et cetera, to create these things. I know that maybe not everybody wants to think that we're motivated by that in our public policy, but listen, it's politics. Is that part of what's going on here? I mean, are there companies out there that are just raking it in over this?
I suspect that there are companies that are making money as a result of this, and there are companies that historically have benefited from convincing the legislature to mandate assessments and counseling for certain types of offenses. But there's kind of a flip side of that argument as well. If we're going to mandate testing and we force it to be done through the government, and the government has a monopoly on this, there are concerns that maybe they're overpriced or maybe they're not well suited to do what private industry could do as well. So I think there are flip sides of that coin as well.
Sure. Okay. Well, that makes sense. I think what we're coming out with this discussion is that a broad, one size fits all approach doesn't work. We need to leave some room for flexibility and basically for judges to decide on an individual basis. I think that's really where we're coming from this.
I agree, and get the legislature to provide funding to the Department of Corrections. Director Birch and her staff are the experts in dealing with these things. Get them funding so that they can identify and help people prior to trial, rather than waiting until. And look, I mean, there are a lot of people that should be diverted from the criminal justice system completely. That for mental health reasons or medical reasons or whatever, should be handled. Their cases should be handled outside of the criminal courts, because the criminal courts aren't well suited to address the dynamics of individual defendants. So I'm hopeful that we'll continue to move toward pretrial services, which is used universally in the federal system. And I think it will, the inequities of this type of statute and its application can be ameliorated by having pretrial services.
Mark, thanks for your time.
You bet, Rob. Thank you.
That's it for today's Plain Talk podcast. Remember, new episodes come out most weekdays right away in the morning. They schedule them to be released at 4 o'clock in the morning. So if you're up that early, you can certainly download the podcast right away in the morning. If you ever have any feedback on the show, you can email that to rob@sayanythingblog.com. Questions, if you're having trouble listening to the podcast, if you're wondering other ways that you can access the podcast. If you have questions for my weekly guests, Senator Kevin Cramer, Congressman Kelly Armstrong, send all of that to rob@sayanythingblog.com. Follow me on social media. I'm Rob Port on Twitter, Facebook. Say Anything Blog has Twitter and Facebook accounts. Very easy to find. Follow me there. If you follow one of those social media feeds, say hi, because I like it when people say hi. And thanks for listening. We'll talk again.